with the evolution leading to the adoption of a civil code in 1825, which has been revised in 1870, and we will conclude by discussing the ongoing revision and translations that take place at present in Louisiana. Code or digest, what is the difference? The difference lies in the abrogation clause. If you look at the French Civil Code of 1804, the law putting it into force had a pretty strong and energetic abrogation clause saying that the Roman laws, the ordinances, the general and local customs, charters, regulations, etc., all cease to have the force either of general or of special law concerning the subjects covered by the present code, which means that the code is actually breaking with the past. It indicates, it tells the judge that in the future, courts are to apply the civil code and they may no longer refer to Roman law, customs, royal ordinances, and so forth and so on. In Louisiana, you do not have such an energetic abrogation clause. The Act of 1808, enacting the digest, says that whatever in the ancient civil laws of this territory is contrary to the disposition contained in the said digest or irreconcilable with them is hereby abrogated. That looks like abrogation language, right? But you've been educated into the techniques of interpretation. Don't you see the possibility here of using an a contrario argument? If you turn that proposal around, what does it say? It says, a contrario sensu, that whenever the digest does not contradict the earlier law, or can be reconciled with the earlier law survives, which indicates that the digest is what the name digest actually indicates, a sort of summary of the principal rules that derive from the older laws, with occasionally some change. May have here or there a few rules that cannot be reconciled. So that indicates that rather than having a break with the past, you have a continuity of the law. It's a beautiful idea. This is exactly what the Louisiana people wanted. They didn't want change. They were really animated by conservative views when they decided to keep the civil law tradition. But by doing this, that, as we all see, created practical problems. And the problem can be exemplified with a case, Kotan versus Kotan, that was decided in 1817, shortly after statehood. In this case, which was that came all the way up to the Louisiana Supreme Court, a married man died, leaving a widow, and the widow was pregnant. The child was born, but only survived a few hours. And the question was, did the child live long enough to inherit, in which case the child would inherit from his father, and on the child's death, the estate would go to the mother? Or was the child born, did the child die too early to have the capacity to inherit, in which case the estate would go to the husband's father and not to the widow? So what law did we have in the digest? The digest in Book 1, Title 1, Article 6, says, is giving a definition of abortive children. Abortive children are such as by an untimely birth are either born dead or incapable of living. So, if the child is born dead or incapable of living due to untimely birth, the child is abortive and is never to be regarded as a legal person, and the child cannot inherit. But how long do you have to live in order to inherit? What is the test? Is there any test to decide that the child is abortive or not? You see that the language that you have in the digest is rather vague. Interestingly, lawyers in Louisiana remembered that under Spanish law, a child naturally born was said not to be abortive if it lived at least 24 hours. There was this minimum of 24 hours that you found in the recompilations of Castile. And you see that earlier Spanish law was more precise, if you will, than the digest. So do these two texts say the same thing or not? Can you reconcile them? Because if you can reconcile them, then the old rule survives. And you may say that unless the child survives 24 hours, the child cannot inherit. And by the way, in the Kotan case, though the matter was controversial, it was accepted that the child survived some 8 hours, so did not make it to 24 hours. So you see, you had arguments on one side, but look, the drafting of the digest is different. It refers to untimely birth, born dead, or incapable of living. Maybe, if you die in a few hours, you are incapable of living, but maybe that child would have been capable of living, but just happened not to make it. And you get this way an idea of the complicated or sophisticated discussion that you had after the adoption of the digest, okay? But before the digest, you would simply apply the old Spanish law. Now you've got to check whether the digest is in line or in contradiction with the earlier law, which means that you have to develop arguments based on the digest and oppose these arguments to arguments based on the earlier law, and judges have to decide whether you can reconcile or not. So instead of simplifying the law, you're actually making the law more complex. The court decided by a majority that the digest was not incompatible with the earlier law. So since the child in the present case did not live 24 hours, but only 8 hours, the child was reputed abortive, was deemed abortive, and did not inherit, and the estate went to the father, or the grandfather, actually. There was, however, a dissent in this case, a dissent by Justice François-Xavier Martin, who was originally from France. He was a man from Marseille. However, the dissent does not appear in Martin's report, but having read the book that François-Xavier Martin wrote on the history of Louisiana, I found his view or his opinion, and I can second guess, I could base what he writes on this book, reconstruct the dissent. Here is what he said. He was actually discussing the digest. In practice, the work was used as an incomplete digest of existing statutes, which still retain their empire. You see, the old law, the old statutes were still alive, writes Martin. And their exceptions and modification were held to affect several clauses by which former principles were absolutely stated. So he is actually complaining about the survival of the earlier law. And he is complaining that thus the people found a decoy in what was held out as a beacon. So instead of having a luminary who will make the law more accessible and easier to administrate, we have a decoy. We are led to believe that the law is like this, when actually lawyers, by getting at all text written in Latin or Old Spanish, will prove that the law is otherwise. So Martin was unhappy with the state of affairs and thought that judges in Kotan had better said that the language of the digest was to prevail. If you are interested in the thinking of François-Xavier Martin, you can read my short article. It's only 6 pages, where I present François-Xavier Martin as the father of Louisiana jurisprudence, present his views on codification, jurisprudence, legal education, and practice. So, deciding that way that the old law was to survive actually happened to defeat the very purpose of the digest, because it made it necessary to refer to old texts in foreign languages, in Spanish or in Latin. And by the way, these texts were not easy to find. Few people had them in their library. Moreteau, for sure, had all these texts. I mean, he had a phenomenal library. We have kept the catalog of it when it was sold at auction after his death. So the purpose of the digest was actually to collect the laws in a single work without recurring to multiplicity of books, which, being for the most part written in foreign languages, offer in their interpretation inexhaustible sources of litigation. So the aim of the digest was to avoid this, but because it was understood to be a digest and not to abrogate the earlier law, we got into these problems. Now, the question to know why we moved from adopting a code to adopting a digest has been discussed by Professor Vernon Palmer in the Tucker lecture that he gave years ago here at LSU. The Tucker lecture is the signature lecture that is offered every year by our Center of Civil Law Studies. Palmer is trying to find reasons why, in the course of adoption of the code, they decided sort of last minute to make it a digest. And maybe one of the explanations would be that if you decided it to be a code with a sort of radical abrogation clause, breaking with the past, that was a strange message that you were sending to the governor of the state, saying, hey, you're changing the law. You said you wanted to keep your old civil laws and you're adopting a new model, a codified model, and breaking with the past. You may as well adopt the common law. That would have defeated one of the reasons why they wanted to keep loyal to the civil law tradition. The other reason, which is discussed by Palmer, is the natural law mindset that people had at the time, and the idea that law is the law because it is in conformity with reason, the nature of things. And legislation is important, but it's just giving a guideline. And you may always go beyond the guideline and to earlier text to illuminate what the purpose of that text was or what the law really is. A sort of resistance to legislative positivism. This is a fascinating episode, by the way, in legal history worldwide. The situation in Louisiana keeps fascinating scholars the world over about what it means to codify or to adopt a digest. So here you have it in the Act of March 31st, 1808, the language that appeared in the earlier slides. So they found at the time no better remedy than saying, okay, our digest is imperfect, maybe we should adopt a new enactment. And this is something extraordinary because just a few years after codifying the law of Louisiana in the digest, a new civil code will be adopted in 1825. I mean, count the years. It's only 17 years after. You do not see any jurisdiction in the world having two civil codes adopted in the span of less than a generation. That is something that is remarkable, especially in a territory or in a state now, that was not heavily populated and had limited resources. However, Louisiana was known to have formidable lawyers, very educated people. And again, this is something that keeps fascinating legal historians to this day. You have here Article 3521 of the Louisiana Civil Code of 1825. From and after the promulgation of this code, the Spanish, Roman, and French laws be and are hereby repealed in every case for which it has been especially provided in this code. You have here a much more energetic, a much stronger repeal or abrogation clause than we had in the digest. It is nearly as strong as the French one, but I won't discuss the nuance here. By the way, I want you also to be aware of the fact that in the meantime, Louisiana, becoming a state, made a strong commitment to protect its civil law origins. The Constitution of 1812 has a provision which obviously does not come from the parent text, the Constitution of Kentucky, but has been written especially for Louisiana. You have it in its present version because this rule that I'm about to read is to be found in every constitution the state has had from 1812 to the present Constitution of 1974, and we had a few along the road. A bill enacting, amending, or reviving a law shall set forth completely the provisions of the law enacted, amended, or revived. No system or code of laws shall be adopted by general reference to it. This language is sort of mysterious. What is the point that they are making? Well, this clause is there to avoid a phenomenon that we would describe as adopting the common law by reference. Adopting in a statute saying, and by the way, for whatever is not regulated in our existing statute shall be regulated by the common law, which would be a sneaky way of impose the application of the common law in the state. You see, this is meant to avoid wholesale adoption of the common law. It would be unconstitutional to do so. So whenever our legislators want to bring some common law doctrine or element or solution into our law, they have to make it by an explicit text, by a statute containing all the rules that we want to bring in. It cannot be done by reference, which would allow then our courts to create precedents based on the common law, even on matters that could be actually governed by the civil code. Let us now address the future of the Louisiana Civil Code and see actually what has happened after 1825. And I will go rather fast in that part of the presentation, but we will come back, or you had opportunity to come back to the detail through your reading. The Civil Code of 1825 was written in the French language and translated into English, just like the Digest of 1808. It is even longer than the digest. It has more lengthier definitions at times, but it is also more French. There are more references to the French Civil Code of 1804. The text was entirely rewritten after the Civil War, In 1870, the state got a new constitution, which, by the way, say that from now on, English is going to be the language of the state. You're no longer making room for legislating in French or even educating the kids bilingual, in French and in English, as was the case before. And this new civil code adopted in 1870 will be in English only. We lose the French version. The text, what was the difference between the two enactments of 1825, 1870? The abrogation of slavery, of course. All the provisions that had been brought from the Black Code into the Digest and had been reenacted in the Code of 1825 were repealed. And that was an occasion, an opportunity to do a cleanup of the text, to bring into the civil code legislation that had been adopted in a haphazard way outside the code, and update and do a few updates here and there. This text has been the object of ongoing revision starting in the middle of the 20th century and becoming very active in the 1870s and 1880s. And we may say that we are coming now at a point where most of the civil code, maybe 80% of it, has been revised one way or another. For this to be done, the legislature created a Louisiana State Law Institute by an act of 1938. Excuse me. And this institute was there to monitor and shepherd the development of the civil law in the state, and also monitor the revision of the code. It works as follows. For each project, a reporter is appointed, and a committee composed of law professors, practicing attorney, and judges will work on a revision of parts of the code. They will make a draft, and the draft has to be approved by the committee before it actually goes to the council of the institute. And once adopted by the council, it is sent to the legislature. The legislature has a practice of adopting the revision without changing much, because it is so well prepared that unless there is something really contentious, it is usually adopted without much amendment. And the practice was adopted to do a piecemeal revision. Rather than revising the entire code all at once, we go title after title. You will study in obligations the law as it has been revised, the revision of Title III and Title IV of Book 3 of our Civil Code, made in 1984 under the leadership of LSU Professor Saul Litvinoff. In civil law property, you will study revisions made in the late 70s under the stewardship of Professor Yiannopoulos, who'd been at LSU and finished his career at Tulane. Both are no longer with us, but we are great names of Louisiana civil law, and you will hear pretty often of them and read their texts. So the revision has chiefly for purpose to update the civil law whenever it is necessary, because it was very archaic. You see, the text of 1870 was still made at a time when society was dominated by the male, and with gender equality, a number of provisions had to be changed in family law, in marriage, in matrimonial regimes, etc. So these updates were really necessary. At times also, the purpose was to try to bridge some differences between the civil law and the common law, or present the civil law in a way that it is more compatible with the common law. You see, the problem that Louisiana is facing is having a different legal system. It sometimes worries businesses in the other states, and they are thinking that, do we really want our contractual transaction to be regulated by the civil code of Louisiana? Is it business friendly, like the laws of Texas or Alabama? So efforts have been made to keep developing the Louisiana Civil Code, being loyal to the style of the civil code, in civil code style, but sometimes with substance that matches, if you will, the solutions that you would have in the common law states, which is making our civil code quite interesting because it is a civil code that is maybe more compatible with the common law than the civil codes of France or Germany. Also, another aim in the revision is to keep the code apace with other civil law countries. And it's remarkable to see that when we are revising the titles of the Louisiana Civil Code, especially when it has been done under the leadership of Litvinov and Yiannopoulos, these scholars were very familiar with the laws of Europe or Latin America. And our code is actually very international in its sources of influence. We are shopping around, and Louisiana is known to be a wonderful land or territory for comparative studies. You see that in scholarship, but also in lawmaking. And for that reason, the experience of codification and revision in Louisiana is a sort of model. I don't hesitate to promote the Louisiana Civil Code internationally in my own scholarship and activity. And it's easy to make people understand that it can be, in some respect, a model and a laboratory for experimenting and matching or trying to bridge differences or divides between the civil law and the common law. It's not always a success, okay? Part of the revision or some addition to the code are pretty ugly, like when some statutory provision written in the common law statute style are appended in the code. That happens a lot, by the way, in the law of torts that you are studying at present. But on the whole, it is worthwhile for people and lawyers and jurists in other jurisdictions, especially mixed jurisdictions, to pay attention to what we have in Louisiana. It is of interest also in developing uniform laws in the European Union, where you have to match or bridge the divide between the civil law and the common law, or when developing international law, which is also largely built with common law bricks and civil law mortar. The study of the code, which in addition is accessible in English, which is the international language par excellence. I have to put that in French. That's a reason why the Center of Civil Law Studies at LSU is putting a lot of focus on the study of our civil code. I told you that I started when I arrived with a project of putting the digest online, and then we continued with a Louisiana Civil Code online project where our present civil code is accessible, open source, from a table of content on our website, and it is much more user-friendly than the site of the Louisiana State Legislature. We have also, with the help of the library, published a compiled edition of the Civil Codes of Louisiana, or volumes of the Louisiana archives that give you on the same page the text as it was in the digest of 1804 with the source, the French source, Code of 1804 or Projet de Gouvernement. Then you have the Code of 1825 and then the Code of 1870. You have both languages when the codes were in French and in English. It's a remarkable tool for understanding the law of Louisiana. And again, this is freely accessible from our website. And last but not least, I created, arriving at LSU, a journal of civil law studies that is actually in its 13th year of existence to actually promote scholarship on the civil law jurisdiction in the English language. And we are now acknowledged as a repository, of literature, resources on the civil law in the English language. And I alluded to translations. We had historically a bilingual code. Here we have it again. I have, over a number of 5 or 6 years, supervised and conducted a project of retranslating the Louisiana Civil Code from English back to French. And it is accessible from our website, open source, and it is also available in print. And that's maybe the first time that the Civil Code of Louisiana was published in France. And we do not leave it there. We are at the moment translating the Louisiana Civil Code into Spanish. And these translations have some significance. We want the code to be accessible to legislators, scholars in various languages, as we know that some solutions in our code may inspire legislators somewhere else. Quebec has done exactly the same thing. They have a code in French and in English for the English-speaking population, but they also did a Spanish translation. So I will conclude mentioning the worldwide influence of the Louisiana Civil Code, and look at this map. All the countries that are in red on this map of the world have received, to some degree, some influence from our Louisiana Civil Code. That includes the province of Quebec, when they recodified their law in the early 1990s. But you find also most, if not all, Latin American countries, whenever they adopted civil codes, they looked at the code of Louisiana. Spain, interestingly, Spain codified its law after Louisiana. The Civil Code of Spain, there's been a draft in 1851, but the Civil Code was not adopted until 1889, which is rather late. And since they understood that the Louisiana Civil Code was largely based on Spanish law, it made sense to look at our Louisiana code. You see China on the map. When China adopted its Contract Law Act in 1990 or around, they were shopping around, and they looked also at the revision and the revised law of contract in Louisiana. You have a Baltic country that has also looked at our code, the Philippines. And I should color in red Japan, because I recently found that our code has had also some influence in legislating in okay, and this is the last thing, and I give you that as a gift, is a tool for you to play with, is the Jury Globe website that has been created by the University of Ottawa in Canada. And it gives you maps of the legal system in the world that you can identify which country has the civil law, the common law, who are the mix. You see on that map that Louisiana and Quebec are identified as a mix of civil law and common law. And you can zoom in and find some information and travel the whole world. I would certainly encourage you to travel. And by the way, I want you to hear in the context of that class that we are working at offering next summer a program in Lyon, but more will be told later on. Thank you for your attention, and I will see you next time in class or in the next video.